Hello, Badm 107, Section 76 students. This is the next video. By now you will have seen the one on Chapter 20, Intellectual Property. And as I mentioned, I have posted will have posted a problem on Moodle, which you're supposed to do and bring to class, and then we can review that chapter. In the meantime, this one is intended to finish off the chapter on insurance. And so I think we got to about slide 123. Let me just check that. Yes, slide 123. And we're looking at the types of insurance, and we're into operational insurance. So the numbers 13, 14, and 15 on the screen, when you look at the lecture guide, are the types of insurance you get for the operations of business. And they are mutually exclusive in the sense that if you have a marketing firm or if you have a consulting firm and you're providing a service, then you want to get commercial liability insurance. If you are producing a product and there is some potential danger with that product, either the negligent manufacture of goods or you have a duty to warn them about a potential danger, even in the safe use of the product, then you want to get product insurance, which is becoming more and more commonly referred to as product liability insurance. The third type is professional liability insurance, and this is what doctors and lawyers and engineers and accountants get. They are the recognized professions, and the recognized professions, because they have to have insurance to operate, makes them a bit of a target as far as lawsuits go, and an easy target in the sense that if the person suing the lawyer wins, there's a pot of gold at the end of the rainbow. Consequently, the premiums are extremely high. For example, lawyers pay, I think, about $25,000 a year in professional liability insurance, and then the first deductible is $5,000, and for a second claim, it's $10,000. So it's pretty steep. So if you're a professional banker or you're a professional marketer, that may be the way you want to portray your business to the world. However, when you go to see your insurance agent, you might want to say, I'm a marketer rather than a professional, because professional means high risk, and high risk means that you'll pay a large more in premiums. The next type of insurance is heirs and omission insurance, and corporations get this to protect their directors and officers. Quite often, business decisions are made with imperfect knowledge, and problems can result in losses, and people can sue the corporation, and they also sue the directors and officers. So this type of insurance provides not only protection against having to pay out damages, but it also provides insurance to fight the legal claim, to pay for the legal fees. For example, when I moved up to the Sunshine Coast, I was asked to become a director of the Chamber of Commerce. And after doing so, I found out the reason that they wanted me on the board was because they had 2 lawsuits commenced against them, and they needed some free legal advice. Well, the first words out of my mouth were, do you have heirs and omission insurance? And all chambers of commerce had to, and therefore any losses that they would suffer would be payable by the insurance, and my legal fees, because I handled the 2 cases, were paid out of the legal fees. They were nuisance cases and we got rid of them, but still it was stressful for the people involved. In addition, you may, during your business careers, be invited to serve on some sort of a charitable board. And while you might want to make a contribution to society, you don't want to contribute your house. So the first thing you should investigate when you become a board member for a charity is, do they have heirs and omission insurance to protect against losses? The next type of insurance is rescue insurance, generally used in adventure tourism businesses when people are out in the wilderness, but it can be utilized for lodges, like my client up north has a lodge and is in a remote area. If somebody gets sick, they can call in a helicopter and the insurance will cover it, that sort of thing. I was on a board, a charitable board, and we were putting on a sponsored event, and I made sure we had errors and omission insurance, but because we were going to have this large event and may have to be canceled ahead of time, we got event cancellation insurance, and that would pay for things like signage that you've had done, tickets, pay for security, all sorts of contractual arrangements to put on a big event. And then you have to cancel, well, you give the money back, but you've already had to pay for some of those services, and so event cancellation insurance covers that. Employee health insurance is something that, for example, Capilano University gives to its faculty because faculty are highly mobile. I got a letter from Hawaii, the University of Hawaii, one time and said, would you like to come over and teach law courses for 2 years? And well, yeah, I would, particularly when you're looking at the weather that we've got here. But I couldn't do it because my health benefits and my pension plan would be affected at the university. So they do it to be nice to their employees, but they also do it to make it a little harder for their employees to move on. If you're running a restaurant and you have servers, very expensive, this type of insurance, so you wouldn't get it because servers come and they go and they come and they go, and they're fairly easily replaced. And so you would want to get some type of insurance that is for the owners but not necessarily for the staff. All right, the next is legal expenses insurance, and there's a whole plan out there now where you can pay a little bit into the fund, and your legal expenses will be covered for wills and small claim suits and things like that. Businesses can pay a substantial premium and get legal expenses covered in the event of lawsuits and that sort of thing. And then the last one on the list before we get to insurance by operation of law is bailment. If I have a business and I like a watch repair shop, but I also sell watches, then I have inventory that if a burglar broke in and stole it, then that inventory, of course, would be covered by my theft policy. But all those people that brought in their watches and gave them to me for repairs, well, those don't belong to me, and so my theft policy will not cover that, or burglary recovery, or whatever. My policy will not cover it. What I've got to get is bailee insurance, because remember when we talked about bailment, someone comes and gives you their watch. They want to get it back in better condition. They want it repaired, in return for which you'll pay them. But they're not giving you title. They're merely giving you possession. So because you have possession but not title, your theft or burglary or robbery insurance won't cover it. You have to get bailee insurance. Now, in the event that I do put an insurance problem on the final exam and I have a little scenario, there will be a trick question in there, and it will be, what insurance should this business consider getting? And a knee-jerk reaction is to say, well, they should get WCB and they should get employment insurance for unemployment in case you have to lay people off. Well, the reason that's a trick question is I say, what should they think about getting? Well, you have employees, you've got these types of insurance automatically by operation of law, and you'd better start paying WC payments and you better start paying EI, or you're going to be fined and you'll have to pay the back payments plus interest. So those are insurance by operation of law, and I am just going to zip to my next screen, so hold on one sec. Okay, the next screen deals with the whole concept of when your policies come into effect. We talked earlier on in contract law, I think it was chapter 6, about a telephone call, and when you hear it, then the contract comes into effect, that sort of thing. Well, that's what we're talking about now. When is there an offer, when is there an acceptance, and when is the contract in effect? And for life insurance policies, it's really easy. You have to have paid your premium, and you have to actually have your policy. So I decide that, oh gosh, I need insurance because the university's sending me to Badm to stand to teach, and for some reason they're only giving me a one-way ticket. Just kidding. Anyway, I call up my agent, Bob, and I say, hey, Bob, I need insurance. And he says, sure, Peter, no problem. And he says, oh, you need a medical examination and then you have to pay your premium. And so I do the medical exam and I pay the premium. And he says, okay, Peter, you've got life insurance. We'll be sending the policy out too. And I think, hey, that's great. And I get on the plane. Hopefully not. But if it happened, I would not be covered by life insurance because I have to pay the premium and get the policy in my hand. That then raises the question of what about those machines that sell insurance at the airport? You know, you go there and there's a Coke machine and there's a chip machine and there's a cigarette machine and then there's the insurance machine. Well, how do those work? Well, what happens is you walk up and you pay some money and you pull a little cord and out comes the policy. So you've got life insurance. You've paid your premium and you got your policy. But you don't want to take it on the airplane with you for obvious reasons. My mother-in-law went to Greece and she got one of those insurance policies, and when she came back she gave it to me and she said, would you check it to see if there's any residual value? And I said, why have you got it? She said, well, I took it with me. Well, if, you know, plane crashes and oh look, there's a charred body, and oh look, there's a policy. Oh, it must belong to her. Obviously, the idea is that you get that a policy. It comes in an envelope. It says a fixed stamp here and send it to somebody. But it's immediate. You get it. You paid your premium, got your policy. Property insurance, though, is completely different. Property insurance is effective the second that you ask for it and the agent says yes. My clients up north, Urs and Marianne, bought a house in North Vancouver, and I handled the purchase and sale. I asked them at the time, do you want me to get the insurance on the house the day that you take possession, or do you want to take care of that yourself? And they said they wanted to do it themselves. But then I'm one of those lawyers that tends to worry a little bit, so the day before the transaction was to complete, I called Urs and I said, have you got your insurance? And he went, oh no, I forgot. And he said, oh, that's terrible, I'm leaving town. I'm on my way to the airport. And so he gave me the name of his agent and he said, go ahead and get the insurance in place. I called up the agent at Barton's Insurance, and in the lecture package that you've got on page 15, I think it is, there's a sample of their document that I'm going to be talking about. And I asked them to send, or to make sure that there was insurance on the property effective the next day, because that's when they're taking possession. And their agent said, yes, you've got it, you're insured. But that sounds great. And that's the law. The difficulty with that, of course, is that let's say it's Bob, and I say, you know, Bob, give me the insurance. And he goes, yeah, sure, Peter, you got it. And Bob's a very diligent man, and it's a busy day, and so he puts the documents in the briefcase of his car, and he's driving home, and he's going over the Broad Street Bridge, and he takes a hard right. Well, there is no hard right. And so when he goes into the water, and they pull the car out, and they take it to the impound lot, and they take poor Bob's body to the morgue. Well, nobody goes through the trunk of the car and says, oh, wait, here's some insurance policies partly filled out. We better do something with them. It just sits there, right? And the poor widow will get her insurance on his life, and the car will be covered, and so it'll be taken away and disposed of. And you've got insurance, but unfortunately, you're the only person in the world that knows that. And so 7 or 8 months later, you have a loss, and you call up the insurance company and you say, hi, is Bob there? And they go, oh, no, Bob's no longer with us. And you say, oh, well, where did Bob go? And they go, we're not quite sure. You've got insurance, but there's no proof, and the insurance company is not likely to pay out the claim. So what I did was, with Barton's Insurance, I said, send me a binder. And they said, yeah, sure, we'll get that out on Monday. And I said, no, the transaction's closing Friday, and that's tomorrow, so I need it today. And they said, well, no, we're really busy, we'll send it out. And I said, no, you'll fax it to me today, or I'll go somewhere else, because I need to know that it's in place. So they're a little annoyed, but they faxed it through to me. It's a one-page form. They fill it out. You can see it on page 15 of the lecture material. It just says the property to be insured, who the insured person is, who the insurance company is, and you'll note that it says loss payee, which is something that'll come up when we review the contract assignments next class, the ones that you were supposed to get into me today. Anyway, and then it says premium TBA. Well, they arrange it immediately, so they don't know what the actual premium is going to be for the property. But my client had a long relationship with them, and so he trusted them, and so they just put TBA in there. They sign it, they fax it to me. I got proof of the insurance. I don't need the policy. So that's particularly important. And I'm just going to bounce to the next screen. All right, the next topic is change in risk, and this will be on the exam. It will be on the exam. Oh, by the way, did I mention it will be on the exam? Because it's really important. One of the problems with insurance policies, of course, is that the insurance companies are looking for ways to not pay out. Legitimate ways, and at least we hope. And one of them is that if there has been a material change in the risk associated with the property that's being insured and they have not been informed, then your policy is either void, or if the accident that occurs relates to the risk, then it's void. But if it's something else, then a risk that was already covered, then you're okay. But it's still dangerous. You have to tell them about the change in risks. And my all-time favorite client, Ray, for example, had modified his operation and had not informed his insurance company of the risks. And when I was talking to him, we dug out his policy, and it said if there's been a material change in the risk, your policy is void. And he went, "Oh my golly," he said, "I've been operating for 3 years without insurance." So, and the reason for this is the fiduciary relationship that we talked about before, where you have knowledge about the risk that the insurance company doesn't, and you're required at law to tell them. You should tell them if the risk increases, but you should also tell them if the risk decreases. For example, my wife runs the B&B, Secret Beach B&B in Gibsons, and when we started operating, we had a smoke detector in the living room, one in the children's room, and one in the entrance hall area. And I suggested that maybe we should put one in each of the suites because, you know, they're non-smoking, but, you know, people, they'll never notice. And so so we did that, and then we also put in carbon monoxide detectors, and we called Bob, the insurance agent, and told him, and gosh, we were told our premium would come down and they'd give us a small refund. So so that's another positive thing about insurance companies after I've been beating them up so badly. Okay, so that's co-insurance, and that ends the chapter on insurance. What we're going to do is we're going to jump over chapter 17, which is principal and agent, because I want to talk about that in class because it relates to corporate law, which is coming up, and it's extremely important, and I want to make sure that we're there, we have the interaction to make sure that you understand it really well. All right, I'll stop there, and we'll pick it up later with chapter, gosh, let's see, 17, 18, we skipped 19, no, 19, Chapter 18, sorry. Chapter 18 is on HR management, and what I'll do is I will either tack that chapter on to this video, or I'll upload this one and put another one on. Thank you very much. Hello students, I'm back. I looked at the time and that was only about 20 minutes, so I'm going to do a bit more HR management on this video, then we'll upload it, and I'll do another one later to complete the chapter. You'll notice on slides 134, 135, and 136, I've got these circles, and the first one is judge-made law. And it symbolizes the fact that initially, when businesses were hiring employees and firing employees and managing their operations, there were no statute laws which had any bearing on the employment situation. And consequently, all the matters that went to court were decisions based on precedent, based on judge-made law. However, as time went on, Parliament began to pass laws in England to regulate employment, and the legislatures and Parliament in Canada followed suit. And so you've got the Employment Standards Act, you've got the Labour Relations Code, you've got the Human Rights Code, you've got WorkSafe BC, all these statutes that then had a bearing on employment law. And so suddenly there's these two overlapping circles where you've got the judge-made law and you've got the statute law coming into play, and things become more complicated. Well, one of those statutes also related to the Labour Relations Code for BC, or the Labour Code for Canada. I'm not particularly favorable towards unions, but we have them because we deserve them. Businesses treated employees terribly, and so the employees began to unite together and bargain collectively against their employer to get better working conditions, better wages, and things like that. Initially, businesses went to Parliament and they said, stop this, and so they passed a law in England making labor unions illegal, and things were still so bad and people were dying on the job constantly that the employees banded together anyway, and so the employers went out and hired thugs and bullies to beat up on people that tried to unionize. Eventually there was battles in the street, and there's more little people than there are rich people, and so the Parliament finally thought, well, you know, if we're going to get reelected, we have to take care of the little people every once in a while. And so they repealed the law that made unions illegal, and they passed the Labour Relations Code. And bingo, suddenly we've got this body of administrative law coming into play. And so now there's three circles. There's judge-made law, there's statute law, and there's administrative law. Administrative law, remember, is when the Labour Relations Board hears disputes and makes decisions that look like precedent, but in fact aren't. They're not precedent because these people aren't judges, and they're not bound by their decisions. But for example, in the province of British Columbia, the Labour Relations Board is very slavish towards precedent. They follow it very, very carefully for certainty in the employment realm. Okay, so the first real slide deals with contracts of employment. And there are two types. There is the term contract, and there's contracts of indefinite hire. The term contract is one where you're hired for a year, and when the year's up, you're no longer employed, and the employer does not have to give you 2 weeks notice that your year is almost up. It's just a contract. It's for 1 year. Bingo, it's over. So if you come in the next day, the employer says, well, who are you and why are you here? You say, well, I work here. He'll say, no, you don't. Your contract's up. Contracts of indefinite hire, though, are ones where they hire you and there's no predetermined termination date. The idea is that you'll work for them for 40 or 50 years, you'll retire, get a gold watch, and go home and die. In situations like that, contracts of indefinite hire, the employer must at some point, if he or she wants to terminate your employment, must either have just cause or they must give you notice to do so. Okay, notice to do so. Then there's this other category that looks a little bit like employment, but it isn't, and that's the independent contractor. The independent contractor, and I'm just going to click to the next screen, is a situation where you want to hire somebody, but you don't want to do the WCB and the EI and all the things that go with maintaining employees, and so you say, well, you just have a contract with me. And businesses have tried that quite a bit, but unless it is really a contract of independent contract situation, then you can call them an independent contractor, independent contractor, independent contractor. And when the dust settles in court, they will be deemed to be an employee. You should never refer to an independent contractor as an employee, or you're just shooting yourself in the foot. The best way to determine whether the relationship is actually one of an independent contractor relationship is if you go to Canada Revenue Agency and they have a list of characteristics, and those are on slide 138. You know, do they own their own tools? Can they hire other people? Do they bill you for the services? Do they have a risk of loss? Do they pay their own taxes? That sort of thing. And there's a list of those. And if you establish that in fact most of those apply to your situation, then the person will be an independent contractor. For example, Urs up north had 3 planes, 2 pilots, and he wanted to hire a third. And he thought, well, I'll hire him as an independent contractor. And he said, he contacted me and he said, can I do that? And I said, well, does he only work for you? Yeah. Do you give him the tools of the trade? Yeah, I give him the airplane. Can he work for anyone else? No. Does he bill you for his service? No. Do you control his hours of operation? Yeah. And I said, well, you know, then call him an independent contractor. Call him an independent contractor. But when the dust settles, he's just an employee. So there are ways you can do that legitimately. We leased the aircraft to a corporation that he owned. He paid lease payments to Urs. He then worked for Urs, and he would bill for his services, and Urs would pay, and he was entitled to actually fly other people on times when he was not working for Urs. And so we did a number of those things to establish the fact that he was an independent business person. Okay, then we'll just click to the next slide. Pardon me, I've gone too far. Here we go. Okay. We then get into the situation of trying to determine when it's necessary in an employment relationship to provide notice to terminate an employee and when not. And so an independent contractor, he works for you, you don't have any work for him, he doesn't work for you, you don't have to say 2 weeks notice to leave, that sort of thing. But if you have an employee of indefinite hire, then at some point you have to let this person go. You have to provide them adequate notice. And the thing to remember here is that 2 concepts of law come into play here: judge-made law and statute law. The statute law is the Employment Standards Act, and it's very specific. It says that if you hire an employee and they work for over 3 months, then they are required to receive 2 weeks notice to let them go. Less than 3 months and they're in what's called a probationary period, and you can let them go at any time. You don't have to give them the reason, but you have to have a reason. That sounds odd. We always, as lawyers, used to say it's safer to just say your services aren't required. And when they say, "Oh, what did I do wrong?" You say, "You did nothing wrong. Your services are just not required." You know, well, is there something else I should? You know, no. There's nothing you've done wrong. You're just not required. There was a court case not too long ago where the judge says you can let them go because you don't have to keep them on. There's a probationary period, but you have to have a reason. And there was one person who, and the court case involved a lady who did her job very, very well, but her interpersonal skills were terrible. Everybody in the office hated her, and she was rude and abusive to everyone else. And so the fellow said, you know, well, thank you, your services aren't required. And she said, well, you know, what did I do wrong? And he said, you know, you're in the probationary period. Thank you, but goodbye. And she sued, and they got into court, and the judge said, okay, you can let them go, but you have to have a reason. Now, you don't have to tell them at the time, but if they sue you, you have to have a reason. And they were lucky enough to have a reason, and they had documented it. And so the judge said, fine, case dismissed. But the case stands for the proposition that you should keep a file on them and have a reason for dismissing them. Okay, once they're through the probationary period, they get 2 weeks notice. After 2 years, after 3 years to get 3 weeks, 4 years, 4 weeks, 5 years, 5 weeks, 6 years, 6 weeks, 7 years, 7 weeks, 8 years, 8 weeks, 9 years, 8 weeks, 10 years, 8 weeks, 12 years, 8 weeks, 48 years, 8 weeks, 642 years, 8 weeks. So the Employment Standards Act has an 8-week maximum. After 8 years, whatever you work, under the Employment Standards Act, you're only entitled to 8 weeks notice. However, judge-made law, judges said, well, that's the statute minimum. There may be situations where the person is deserving of more than the statute minimum. And this is basically a managerial position. If you're in management, then the Employment Standards Act provides the minimum, but you have to look at the industry that you're in and how much notice people get. And roughly, very roughly, because it varies from industry to industry, but roughly it's about 1 month per year of service. So I had a friend who was employed with Canadian Airlines International. He'd been with them for 9 years. They were letting him go. They gave him 9 months notice that he was being terminated. They knew he wasn't going to be working for them in the 9 months. He's going to be looking for a job. So they said, you have 9 months notice, so we're paying you for 9 months. You have an office, you have secretarial services, you can start a business, you can send out resumes, you can write a book, you can do anything you want. But at the end of 9 months, you're terminated. And then they also provided counseling services because particularly men, women seem to have thicker skins than we do, but when men lose their jobs and they're no longer the breadwinner for the family, they suffer mentally. And so they provided counseling services as well. And they also said you get a free ticket anywhere you want to go in the world anytime if you're going for a job interview, because it was an airline, so it didn't cost them anything really. So they dismissed their employees, and they did it very, very well, as nice as possible. When you're getting dismissed, it's not nice, but it's as nice as possible. So the Employment Standards Act sets out the minimum. The judge-made law sets out the maximum, and then there's some cases that come into play and throw a monkey wrenches into the works. The first is Lazarowitz versus Orenda Engines, Supreme Court of Canada case from quite a number of years ago. But there was a BC company. It was on the stock exchange. It was a bit of a scam, but it looked like it was going to be a company that made small engines for lawnmowers and things like that. And the hype was really big for the company, and they were getting ready to launch and sell their shares. But they needed somebody at the head, and so they went to this fellow, Zarowitz, who was the president of a company, I think, in Manitoba, and he'd been there for 22 years, and he had all the experience necessary. And they said, "You come work for us, and we'll pay you lots of money." And Lazarowitz said, I've had 22 years here, and if I go to work for you, it's risky. And they said, no, it's not risky. This is long-term employment. This company is there for the long haul. It looks good. This will be the pinnacle of your career. You'll get more money, more prestige. We'll call you the CEO. So finally, Lazarowitz says, "Oh, okay," and he comes, and of course they hype the shares on the basis that they've now got the professional management they need, and the shares launch, and the promoters blow out their shares, and the shares drop in value, and the company goes insolvent. And Lazarowitz says, "Well, what about me?" And they said, "Oh, well, you haven't even been here a year, so we'll give you a month's pay." And he sued, and the Supreme Court of Canada said, well, if he's enticed away with promises of long-term employment, then in order to adequately compensate him, you not only have to look at how long he has been with Orenda Engines, but also how long he was at his previous job. Pardon me. And so he got 22 months pay in lieu of notice. But the company's insolvent, so no money. But the promoters are the ones that made the negligent misrepresentation, and they are the ones that have to pay. If they can't, the company is vicariously liable. But the promoters, of course, blew out the shares and they had all the money, so there was no problem there. So that's Lazarowitz. The next one is Wallace versus grain growers, United Grain Growers. This was a situation where they gave him the required amount of notice. He was a president, and they let him go. And then when people said, well, why did you let him go? They went, we couldn't prove anything, but something was going on there. And Wallace found out about that, and he sued them. And again, it went to the Supreme Court of Canada, and the Supreme Court of Canada said, you not only have to give him the right notice, but you have to treat him properly. You cannot say, we're giving you notice, but we're really firing you for cause because there was something going on. You can't have it both ways. And so he got a substantial amount of money in addition to his right notice, because they said there should be a pecuniary damage from the way they treated him. And then the next one is even more bizarre, and for the life of me, I mean, the first two make sense. This next one doesn't. And it's out there, and it's a landmine that you have to tippy-toe around when you're an HR manager. And that was Prince versus. No, I'm sorry. I'm going to have to check my slide here. Yeah, Byers versus Prince George. I knew there was a prince in there somewhere. Byers versus City of Prince George. Byers was a nice lady. She ran the booth at the parking lot. People drove in. She took some money, gave them a ticket. They'd park, they'd leave. She did that for, I think it was 12 years. A lot of years. Anyway, the city has to save money somehow, so they decide to put in a booth or a machine that just gives a ticket and the people pay. So they don't need an employee anymore. They give Byers notice, proper notice. She's been there for 12 years, so she's entitled to 8 weeks, right? Under the Employment Standards Act, because she's not management. So she's entitled to 8 weeks. So they give her 10 weeks notice and a glowing letter of reference. And she sues because she cannot get a job anywhere else. It gets into court. It goes up to the BC Court of Appeal. So we got 3 judges now, 3 judges, very learned people. And they decide that if this person has done nothing to improve his or her skills during the time that she has been employed, and you have to let her go, and there's no work out there of a similar nature so that she cannot or he cannot find a job, then you have to give them more pay than just the statutory minimum, which doesn't make sense because for a number of reasons. The first of all is if I have to give Byers more because she didn't do anything to better her skills while she was with me and there's no jobs for her out there, then that penalizes the people that are with me that actually do try to improve themselves. Take computer courses, take business courses, go to seminars, and everything, so that if they lose their job, they'll be able to find another one. So I have to give Byers more because she's what? Unemployable? Whereas the person that has done something gets less. Like, where is that fair? And then the other problem we have, of course, is that there's this thing called the Personal Information Protection Act, which says I, as an employer, can collect information about my employees that I need to help me better manage them while they're with me. So I have to collect information about Byers. Hello, Mrs. Byers, how's it going? You taking any courses, or are you just sloughing off at home? Are you trying to do anything to improve yourself, or are you just a slug? And it's kind of invasive. And do I really need that to manage her while she's working? No, I only need that in case I have to give her extra notice when I fire her. So it doesn't make sense from a lot of reasons, but it's out there. And we hope that it's confined to a civil servant employee, perhaps because she's with the city of Prince George, or we hope it's confined to only those jobs where there is no more work out there like it, or something. There's something to narrow it, but it's out there. And I think what you have to do is you have to find out a number of things about your employees as they depart in order to determine whether or not they are employable once you leave, or you might have to give them a little bit more money. All right, I'm just going to pause and get the next screen up. All right, well, things are a little murky out there in the HR world. There was a case out of Ontario that did give some guidance to help employers and HR managers figure out what to do. And that's the Badm case. And he sued the Globe and Mail because he was let go and didn't think that he got the right amount of notice. So the court listed six, I guess I better get the right number, six things that you should take into account when you're letting people go. The first is the length of service, obviously, that they have been with you. The second is the character of the employment. Well, that makes sense. The length of service. It's either 8 years or 8 years or 9 years or whatever. And then the character of the employment means is it the Employment Standards Act that governs, or is it the judge-made law? Then you look at the age of the employee. So, I'm getting up there, and if Capilano University had to let me go, they'd have to stop and think, ooh, who's going to hire him? He's going to work for a couple of years and then he's going to retire. So, why go through the expense of hiring him? And he's at the top of the pay scale. So it would make me less employable out there, even though I've got the skills and obviously one of the best teachers around. But it comes into play. So the age of the employee, then the education of the employee, and this is the buyer's case. Do I have an MBA? Do I have a BCom? Do I have a history degree? Did I take some computer courses? What have I got in the way of educational skills to help me out there? And then there's the experience. Well, I've got experience as a teacher. I've got experience as a lawyer. So they take those into consideration because that's going to make me ultimately more marketable. And then the availability of jobs out there. If we know there's a downturn in the economy and the government is slashing back and there's educational funding and there's going to be a few teaching jobs, then perhaps I'm deserving of more notice because it's going to take me longer to find another job. That's the kind of things you take into play. And then the judge ended those six things by saying, and this is not an exhaustive list. In other words, there may be some other things out there, but you should take care of these six for sure. And then one of the other things out there, of course, would be the Wallace decision. If you look down the list, there's nothing there that says they have to be kind and honest when they let me go. But Wallace would come into play, where you have to let me go and you have to do it with respect. All right, next screen is pay in lieu of notice as opposed to notice. I talked about my friend who worked for Canadian Airlines International, and he'd been there for 9 years. And in actual fact, he was with 9 years with Pacific Western, and then Pacific Western did a reverse takeover and purchased Canadian Airlines International, because Canadian Airlines International didn't last that long. But he had 9 years of experience. And so they gave him 9 months notice. They were going to pay him each month for 9 months. The advantage of doing this is that if after 7 months he gets another job, you don't have to continue paying him. The downside is that if you have an employee and you give them notice, they may, on the job, rob you blind. They may, for example, if they let a teacher go, and we'd take pens and pencils and staples and pads and everything so much that we could open up a stationery store. And so rather than give, just kidding, but it happens. Rather than give them notice what you do is you come up to them on 5 o'clock Friday and you go, Peter, we no longer require your service. Here's 30 months pay in lieu of notice. You go home and hand in your keys. And this prevents things like the person walking back into their office and they're really upset and they go to the computer and they go, oh dear, did I just wipe everything off the hard drive? Too bad. And then they go home. So it stops that kind of thing. You pay them and escort them out and do it with respect, of course. And then the other item on this slide is what we call constructive dismissal. And that is, let's say you're all my my sales employees, and Terry is really, really the best. And so I come to her one day and I say, Terry, I'm expanding the size of the sales force. I'm going to have a hard time managing. How would you like to be the manager of the sales force so that you no longer have to travel, but you have to keep track of everybody for me? And you get more money, you get an office, and you become a manager. And so Terry likes the idea, and she says, sure. And then I promote her and give her office, and everything goes fine for a couple of months, and then bam, disaster in the marketplace, and the sales just drop off. Trump builds a wall between Canada and the United States and cancels NAFTA, and there goes the economy. And so I come to Terry and I go, oh, Terry, I've got to let some of the salespeople go, so I really don't need you as a manager anymore, but you were the best salesperson I have ever had. So starting Monday, what I'd like you to do is come back and work as a salesperson, same salary you were getting before, same conditions you're getting before, because I really don't want to have to let you go. Well, I have in effect dismissed her from her managerial position, and I have hired her again as a salesperson. And did I give her enough notice as dismissing her as a manager? Well, the kicker here is that Terry's been with me for 7 years, so when I made her a manager, suddenly she is entitled to 7 months notice. Okay, not whatever the salespeople are entitled to. 7 months notice. So in order to do this properly, what I have to do is I have to say, Terry, I'm sorry, I no longer need you as a manager. Here's 7 months pay in lieu of notice. Now I would like you to come back and work for me as a salesperson. So if you want to do that, then you can come back anytime during the 7-month period. And otherwise, what I've done is I've constructively dismissed her. If I just say you're no longer a manager. A constructive dismissal is a unilateral change in the terms of employment. Let's make that a little more obvious. We have a contract, and I've taken the contract and changed it. Well, you cannot do that with a contract, not without both parties agreeing. And even if you said, oh, well, okay, because you need the money for your job, you can still actually sue them for constructive dismissal because you're saying, I agree, you got a gun to your head. You've got a mortgage, you have to pay it. Okay, so that's constructive dismissal. And now we're going to shift gears and we're going to get into what we call dismissal for cause, which means that rather than just not needing your services anymore and feeling bad about having to let you go, you have done something wrong. And as a consequence, I want to fire you. Well, it would be really ludicrous if you'd been working for me for 9 years and you robbed the safe at work and took all the money home and got drunk and rolled the company car if I had to say, oh, well, you've been with me, what did I say, 9 years or something? Well, you've been with me for 9 years, so here's 9 months pay in lieu of notice, you're fired. No, that's misconduct. And so I can fire you immediately without notice or pay in lieu of notice. And there's 4 reasons you can do that: misconduct, disobedience, incompetence, and illness, although we'll talk about that one because it's getting a little more difficult. Okay, so we're dismissing somebody for cause. Misconduct is any activity on behalf of the employee that brings the employer's business into ill repute. So this is, stealing from petty cash. This is, I don't know, getting drunk and crashing the company car and things like that. Now, it used to be that if you stole money or stole something from the business, that you could fire them immediately. However, there's a Supreme Court of Canada case in McKinley versus, I think it was BC Tel, where they said, well, it has to be dishonesty that goes to the heart of the contract. So if you are a fantastic salesperson and you stole some money out of petty cash and did something with it, it might be that you have to give a warning and fire them the next time, because that stealing little petty cash doesn't go to the heart of the contractual arrangement. I don't agree with it, but it's there, and it was upheld with limitations in a subsequent case, and I have some information on it, and I'll circulate it in class next time. So a misconduct, for example, somebody comes in, they work every day and goes, lousy stinking job, lousy stinking office, lousy stinking employees, lousy stinking product, lousy stinking boss. And he keeps saying, hey, Fred, you can't do that. You can stop doing that. Yeah, next day, lousy stinking, lousy stinking. Well, eventually you can say, okay, Fred, I've warned you 7 times, you're fired. Because you cannot have that kind of an atmosphere in the business. Okay, so that would be misconduct. Or your employee makes deliveries door to door and somebody starts bad mouthing the product, and the employee says, hey, how dare you, he's a great boss, and you punches the person. Well, you can't do that, and so you could fire them. So that's misconduct, any activity that brings the business into ill repute. Then there's disobedience, and the definition here is disobedience of a legal, a reasonable and lawful order. So I have, remember I had Chase as my janitor, I think, at one point. Well, Chase is my janitor, and I say, Chase, you didn't do the windows. And he goes, I don't do windows. And I go, no, Chase, come on, you're supposed to clean everything here, and the windows are dirty. I don't do windows. Well, I can say, okay, Chase, you're fired, because that would be something that a janitor would be expected to do on the job. But if we were on the 3rd floor, and I said, Chase, you haven't done the windows. And he said, well, I've done the inside. And I go, yeah, but the outside's dirty. And he goes, well, but we're on the 3rd floor. And I go, yeah, but you can go out on the ledge there, and if you hold on, you can get them. Well, that would be an unreasonable order. And so if I fired him because he wouldn't do it, then he would be able to sue me. But a reasonable and lawful order, and I get to fire him. Incompetence is... the definition is there's no difference between a refusal to do a job and an inability to do the job. So here, though, you have to be careful about your hiring process. What did you do to ensure that the person that you hired had the skills? Because if you just hire somebody and then you go, what do you mean you don't know how to run a supercomputer? You said, yeah, you're computer savvy. Well, yeah, I've got a PC. I know what to do, but a supercomputer, hey, well, you're fired. You can't do that because you didn't hire correctly, and so it's wrongful dismissal because you're a lousy manager. But if you advertise correctly, if you look at the applications, if you interview, if you check the resumes, and you hire the person, and they go, yeah, sure, I know how to turn on a computer, and because there's a button here somewhere, then you can fire them because they're obviously incompetent. So incompetent is an inability to do the job. The third one is illness, and this is getting to be really quite complicated. Your ability to let someone go for an illness is if it interferes with their ability to do the job on an ongoing basis. So you phone up, boss, sorry, I got a cold, I'm not coming in today. You're fired. Can't do that. Everybody gets colds, it doesn't interfere with their ability to do the job on an ongoing basis. But some people just have like one illness after another, or whatever, and at some point you can say, okay, you're fired. Where this gets really confusing is something like alcoholism. It used to be that if you were drunk constantly and it interfered with your ability to do the job, you could let the person go. And now they're saying, well, maybe alcoholism is not an illness, it's a disability. And you have to accommodate people with a disability. You have to move them from whatever job they're doing where it's a problem to another job to see if they can do it before you let them go. And the disability factor came into play in two cases. One was there was an engineering operation, and there were a number of engineers in the office, and they were always doing drawings and everything like that on their desks. And one of the engineers over the weekend was in a car accident, and he was paraplegic, and he came in his wheelchair, and he said, "Okay, I'm ready to come back to work." And the boss said, "Oh, well, we can't, because you can't maneuver around the desks, and our washroom isn't wheelchair accessible, and there's no ramp up to the front door, and the elevator is not big enough." And so the engineer sued, and the court said, "Hey, listen, he's in a wheelchair, but he can still do the job, and so you have to accommodate him." And the business had to spend $22,000 to get the washroom reconfigured, to change the layout of the office, and to put in a ramp at the front door. Yeah, and it was a big hit for a small firm, 22 grand. But it seems like the proper thing to do in our society if we have the financial wherewithal to do it. You do not have to accommodate an employee if it means that your business will be teetering on the edge of extinction. And that happened in a case where there was a fantastic server in a restaurant. He was phenomenal. He was always on time. He worked hard. He stayed late. He served people. He was friendly. He was efficient. And he made a huge amount in tips. And same thing, he was in an accident in a wheelchair, and he came back to work, and he said, "Okay, boss, I'm ready to go to work." And the boss said, "Well, there's no way that you can maneuver around the tables. So what I'll do is I'll pay you the same amount of money. I'll build a platform behind the bar, and you can become the bartender." And he said, "No, I'm a server, and I want to serve." And the employer said, "Well, I'm sorry, you're not coming back." And the young fellow sued the employer. They got into court, and the employer said, "I would have to take out 6 of, I can't remember whether it was like 14 tables, 6 of my 14 tables in order to allow him to be able to maneuver." And he said, "If I take out 6 of my 14 tables," he said, "my sales will drop to the point where I will be losing money and I'll go out of business." And he said, "I offered to keep him on at the same salary behind the bar." And the young man said, "Yeah." He said, "But I was making a fortune on the tips." And the judge said, "Have you been paying tax on all that?" And the young fellow said, "Well, part of it." And so suddenly the sympathy of the court went to the employer, and the court said, "Look, your tips are extra. It's not part of the job. Your employer is not responsible for the tips." So the employer was accommodating you, was offering you the same amount of money. Therefore, your case is dismissed, and the employer did not have to take the young fellow back, nor did he have to pay him any money. Okay, so that's dismissal for cause, and now we're going to shift gears, and we're going to get into another topic entirely, and this is probably a good place for me to discontinue, and I'll upload this video to YouTube and get you the link, and then we'll deal with the other one later on. Thank you very much.